40, numéro 40.
Senator McCallum, on debate.
Thank you. Thank you, Madam Chair. Honorable Senators, I rise today to speak on Motion 40 regarding the protection and affirmation of Mi'kmaq Fishers Treaty rights. I want to thank Senator Francis for bringing this important matter forward. I want to acknowledge that the contents of this speech come largely from the Masters of Arts thesis submitted by Ms. Carolyn Tuvey entitled Decolonizing or Recolonizing Indigenous Peoples and the Law in Canada. The committee members were Dr. Jeff Corntassel, Dr. T.K. Alfred, Dr. John Burrows, and Dr. James Tully. The Master's Tools Will Never Dismantle the Master's House by Audre Lorde. Ms. Tuvey's thesis examines the limitations and drawbacks in using the law with respect to cases involving Indigenous rights and title. She demonstrated that tackling issues of rights and title through the Canadian judicial system is potentially dangerous to the advancement of Indigenous rights and title. So what are the alternatives to legal forms? She states, law cannot be separated from culture, and law operates to perpetuate culture. In the case of Canada, the law operates to perpetuate a colonial culture. Therefore, when we speak of Indigenous peoples emancipating themselves through the use of a foreign and imposed law, we are asking Indigenous peoples to adopt the very culture that created their oppression in the first place. Ms. Tuvey questions, in 1982, Section 35 was added to the newly patriated Constitution of Canada. What has been the result of Section 35? Have conditions changed for Indigenous people? Has it become easier to make rights claims? Have Indigenous peoples been enabled by Section 35 to speak in their own voices? Has it led to the revitalization of culture? By entrenching Section 35 of the Constitution, the politicians were effectively ensuring that Indigenous peoples would have to take any and all claims to court, further legitimizing the institutions of the Canadian state and removing Indigenous issues from the political sphere. Effectively, Indigenous peoples were relegated to a world whereby they would have to ask for their rights from their colonizing oppressor, and in order to ask for those rights, they would necessarily legitimate their oppressor. The people of Burnt Church experienced firsthand the futility of Section 35 and court rulings on it. Burnt Church was the community most affected in the aftermath of the Marshall decision. When the Marshall decision came down and the Mi'kmaq began to fish, they were subjected to violence and arrests. The community of Burnt Church was attacked directly by the non-Indigenous lobster fishermen. Indigenous-owned lobster traps were destroyed, and pictures of the Department of Fisheries boats chasing and often attacking Mi'kmaq were a fixture on news reports. In the end, however, it was the Mi'kmaq who faced charges of exceeding their legal limit of lobster catches, a limit imposed by the colonizer. Mi'kmaq commander of the East Coast Warriors Society, James Ward, when speaking of the ensuing criminal trial, stated, "No one here has any faith in the judicial system. There's animosity between ourselves and the judge himself, and obviously between the fisheries officers present. This is a system that gives a police officer 2 years less a day of community service for shooting a Native man in Napier Wash. Why should we have any faith in the judicial system doing anything for us?" Ms. Tuvey explains the Marshall decision by saying, R versus Marshall was considered another win for Indigenous peoples. In that case, Donald Marshall Jr. was acquitted of catching and selling eels. The court determined that as a result of treaty and Section 35, the Mi'kmaq do have the right to earn a moderate livelihood. Doug Cuthand, in his article in the Regina Leader Post on September 26, 20th, stated, The term moderate livelihood is not a legal term, and First Nations seem to be the only people in Canada who are subject to it. Ms. Tuvey continues, Marshall relied on a 1752 treaty as evidence that the colonial regime has always recognized the right of the Mi'kmaq to sell fish, given the inclusion of a truck house clause in the treaty. The truck house clause allowed the Mi'kmaq to bring their catch to be sold at truck houses, essentially trading posts, in order that they may earn a modern livelihood, but the Mi'kmaq are prevented from an open-ended accumulation of wealth. This judgment led to an extreme backlash against the Indigenous fishery and led to violent clashes between Indigenous fishery and the Canadian fishery. The Supreme Court responded to this by releasing its judgment in Marshall II, which curtailed the rights earlier acknowledged by the court. The Marshall II court notes that the Indigenous rights were subject to government regulation. The court in Marshall was accused by many of practicing a sort of judicial activism, with many stating that it was indicative of the court's unbridled willingness to grant open-ended rights to the Indigenous. It is not for the court to grant a right that already exists. And more frightening still was that the first judgment was already restrained, and yet, as has been proven by the Marshall case, this restrained acknowledgement that an Indigenous right exists was fraught with such huge political ramifications that the court was forced to bend. The Marshall decision leaves Indigenous peoples with the right to fish and sell their catch, but only within a highly regulated and colonial regime that is set up, maintained, and enforced by the colonial parties, such as the Department of Fisheries and Oceans, the courts, and the police. The Marshall decision made evident just how much the judiciary is influenced by popular opinion, in that the court further restricted the rights it recognized the Mi'kmaq to hold. The judiciary exists as a result of political appointment. The judiciary is ultimately accountable to the politicians who are ultimately accountable to the majority, but it is not accountable to the Indigenous population. As Patricia Montour-Angus points out, the judicial process on which we rely to resolve Indian claims is not accountable to the people whose future it determines. Canada, either federal or provincial governments, on the other hand, can, by the authority vested in its legislative powers, circumvent judicial decisions by passing or amending the statutory provisions. This forces courts to at least acknowledge seriously the position the various Canadian legislatures take on certain issues. No such deference to Aboriginal governments exists in the present balance between judicial and legislative powers. Long before the arrival of Europeans on this continent, the Indigenous people had complex systems governing their fisheries that allowed for sizable catches as well as conservation. In Canada, by 1884, the Dominion government required Indigenous peoples to seek permission from the colonial government to fish for food. This despite the fact that non-Indigenous people did not need a license to food fish. And by 1888, the Indigenous people could no longer sell fish without a license. The DFO has long used conservation concerns as a means to control and in many cases halt the Indigenous fishery. Parnesh Sharma has uncovered some of the disturbing ways in which the DFO pushed Indigenous peoples out of the fishing industry. Sharma details the fishing season of 1995 in which the DFO asked Indigenous peoples to not catch their allocation of fish due to conservation issues. There was no such conservation issue. As Sharma notes, rather the DFO, under intense pressure from the commercial lobby, lied to the Aboriginal fishers and simply reallocated the Aboriginal food fish to the commercial fishery. The decision to violate Aboriginal fishing rights and the terms of the AFS agreement apparently occurred with the full knowledge of the Federal Ministers of Fisheries, Brian Tobin. For the Mi'kmaq, the Marshall decision did not create a right. The Mi'kmaq already had the right. What the Marshall decision did was create a stronger resolve within communities to resume the fishery that had been vital to their communities and culture for thousands of years. By February of 2000, the Mi'kmaq had decided to take the political initiative, partly as a result of the Second Court ruling in the Marshall decision, and define their own rights outside of Canadian courts, outside of colonial legal structures. What resulted was the Esquimalt Fisheries Act and Management Plan. The creation of this came out of a process owned by the community of Burn Church, whereby extensive consultation took place. Many Indigenous communities are at a crucial point where languages are being lost and ways of life are being forgotten. For coastal communities, the need to educate young people about the culture necessitates the return of the traditional fishery. The Indigenous peoples in both the East and West Coast will face continued resistance to their fishery as commercial interests begin to face restrictions in light of diminishing stocks. Going to court confines rights to the state's interpretation of them. It removes the community from defining for themselves what their rights are, what they look like, and how they will be exercised, and puts those rights and the definitions of those rights into the hands of the state, and puts the maintenance of a culture into the hands of the state. And the state has repeatedly proven that its motive is to, at the very least, subsume Indigenous culture, if not outright destroy it. Were gains made for communities as a result of acts of resistance? The actions were successes because of how they brought communities together. In some cases, communities already had a measure of solidarity, but in other cases, communities were brought together that were otherwise fragmented. James Ward stated that the incidents at Burn Church left a lasting impression on the community with a renewed sense of community and pride. After 500 years of colonization, Indigenous people have demonstrated that they are not in short supply of patience and strength. The exercising of rights acknowledges what a courtroom simply cannot, that communities are the sum of all its parts, that issues cannot simply be reduced to one of land, fish, trees. By not simply taking these issues into court, Indigenous peoples are maintaining their right to define who they are, what they are, and what it means to be Indigenous. In a sense, the exercise of rights has become a part of ceremony, the ceremony that is community, solidarity, and survival. Honorable Senators, let's support our fellow Senators and call upon the Government of Canada to uphold Mi'kmaq Treaty rights to a moderate livelihood fishery safely and with the blessings of Canada. Thank you.
En débat, Senator Dalphond.
Senator Dalphond. Thank you, Madam Speaker.
I rise to support the joint motions of Senator Francis and Senator Christmas calling on the federal government to finally uphold the Mi'kmaq constitutional treaty rights to a moderate livelihood fishery and condemning the violence that occurred last year in Nova Scotia to impede these rights. This motion, introduced in November 2020, has added urgency because of Minister Jordan's statement of March the 3rd, indicating the government's intent to unilaterally regulate moderate livelihood fisheries for lobster within the established seasons, alleging conservation grounds. We have all seen Senator Francis and Senator Christmas' statements in response, criticizing serious deficiencies around consultation and conservation claims. The government has also not accommodated our colleagues' proposal for co-management of this resource through an Atlantic First Nations Fisheries Authority advanced in the fall with the support of MP Baptiste. L'échec à long terme du gouvernement fédéral.
The long-term failure of the federal government is without question. Furthermore, successive governments seem to ignore the teachings of the Supreme Court, which go back over 20 years.
Rendered by the Supreme Court on September 17, 1999, and I quote, catch limits that could reasonably be expected to produce a moderate livelihood for individuals Mi'kmaq families at present-day standards can be established by regulation and enforced without violating treaty rights. In that case, the regulations will accommodate the treaty rights. End of quote. In the second Marshall decisions rendered on November 17, 1999, the court added, I quote, the process of accommodation of the treaty right may best be resolved by consultation and negotiation of a modern agreement for participation in specific resources by the Mi'kmaq rather than by litigation, end of quote. Failing a modern agreement, the court further stated that the treaty right may be regulated, even in some cases infringed, for conservations or other compelling public objectives, but, and I quote, a closed season is clearly a potential available management tool, but its application to treaty rights will have to be justified for conservation or other purposes. The complexities and techniques of fish and wildlife management vary from species to species, and restriction will likely have to be justified on a species-by-species basis, end of quote. Further quote, the minister authority extends to other compelling and substantial public objectives, which may include economic and regional fairness, end of quote. To resume, the Supreme Court of Canada has invited parties to negotiate a modern agreement, and failing such a negotiated agreement, describe procedures for regulating treaty rights. The Supreme Court said that the regulations, when adopted, if they constitute an infringement on the right to catch for a moderate livelihood, will have to be a minimal infringement, should result from adequate consultations and should provide for a fair compensation. Par exemple, les titulaires de...
For instance, rights holders from treaties in the Gaspé area, like the Malicite in Vigier, signed an agreement with the federal government in 2019. However, the government cannot impose such a model. The nations which are affected have rights which supersede commercial considerations. If nations wish to exercise their rights under older treaties, this must be respected within the framework of a moderate livelihood, and the government has to respect the choice of the First Nation.
Unfortunately, the government did not act accordingly. The lack of resolve has led to ugly behaviors from commercial fishers when the Mi'kmaq decided to enforce their treaty rights that are constitutional and way more superior than the commercial rights, and a slow response from the RCMP followed. Moreover, earlier this month, Minister Jordan, in her statement, failed to address problems identified by Senator Francis and Senator Christmas, and continues to act unilaterally and to impose a paternalistic approach. Its decision is very regrettable and certainly not respective of the treaty rights. which she says is necessary for the protection or the conservation of the resource. Well, once more, we have a government failing to bring political will to a real problem and to recognize treaty rights, important, constitutionally protected. The recent event in Nova Scotia and previous events elsewhere in Canada have shown that there was a real social problem in Canada. Many Canadians have an insufficient understanding of the history, geography, and reciprocal nature of treaties with Indigenous nations, their constitutional status, and their practical consequences. This lack of understanding is a failure of our education systems, reflective of a history of racist federal policies, as we know from calls to action 62 of the Truth and Reconciliation Commission. Treaties are foundational law. As former Senator Sinclair wrote to the Prime Minister on October 16 last year regarding the violence, and I quote, "This situation is a clear and powerful test as to whether Canada is indeed a country of laws, and there is zero legal ambiguity in the present circumstances with respect to both criminal law and the Constitution," end of quote. In general, we shall not tolerate a misguided view of treaty rights as a valid source of grievance for non-Indigenous peoples such as commercial fishers. All Canadians have derived economic benefits from treaties, including the lands and resources that build this country. Education can also further the understanding of how treaty rights interact with commercial fisheries. I repeat, treaty rights are way superior to commercial fishers' rights. En novembre, de nombreux Canadiens ont...
In November, many Canadians learned that a coalition of Mi'kmaq communities, which Senator Christmas belongs to, had purchased 50% of the shares of Clearwater. This company is the largest holder of fishing and processing licenses in Eastern Canada, but that doesn't fix the problem. The Senate could play a role by explaining the legal distinctions between commercial licenses and a moderate livelihood fishery and the connection with the food fishery and fishery for social and rituals, which are protected under the 1982 Constitution, Section 35.
Opinion polls offer hope that there might be a unifying path forward in full respect of treaty rights and conservation. According to NANAS, almost 3 in 4 Canadians say that the best path forward is the Mi'kmaq lobster fishing dispute. To resolve the Mi'kmaq lobster fishing dispute is to make sure that Indigenous fishing rights are respected while also ensuring that Indigenous fishers follow federal conservation rules. This leaves open, however, what those conservation rules should be and how they should be co-developed. Here, the alleged conservation concerns raised by the Minister appear greatly overstated. The Mi'kmaq lobster fishery is small in scale. In one fishing zone at issue in Nova Scotia, as Senator Keating referenced earlier, we are talking about 550 Mi'kmaq traps compared to 391,000 commercial traps, i.e. 1/7 of 1%. Also important, our American neighbors' example suggests that Atlantic lobster reproduction does not require seasonal regulation of the catch for conservation. In Maine, the lobster capital of the U.S., there are no seasons. The Canadian seasons are apparently more about lobster price, including because seasonal, hard-shelled lobsters may be more safely transported. If this is the case, why is this rationale being publicly conflated with conservation? On March the 3rd, Minister Jordan said, I quote, "Seasons ensure that stocks are harvested sustainably and they are necessary for an orderly, predictable, and well-managed fishery," end of quote. However, if seasons are not in fact required for lobster conservation, it is difficult to accept this conclusion. Management of the overall catch could be sufficient, as stated by Professor Robert Stenek of the University of Maine's School of Marine Sciences. This could be done through co-management with Indigenous nations. Instead, it seems that the government overriding's rationale probably relates to the economic interest of commercial fishers and maybe an upcoming election. For example, the minister referred to the established seasons as distributing economic benefits across Atlantic Canada, end of quote. If the government's primary rationale is economic, the government should be upfront about it. The government should clearly explain its objective with evidence, such as around yields, prices, returns for fishers, so that objectives and evidence may be evaluated and alternatives weighted. Exaggerated claims about conservation do not advance policy solutions or build trust, particularly with the history of right violations. Enfin, j'aimerais souligner que les peuples autochtones.
Lastly, I'd like to point out that for Indigenous nations, this type of argument is rather surprising and even offensive when you think of how colonialism has exploited North American national resources. By the end of the 19th centuries, buffalo were hunted almost to extinction. Their numbers went from 5 million to 1,000 today, and it decimated the Plains nations. Whales were almost hunted to extinction in the North Atlantic, and cod was also almost fished to extinction. So when it comes to the conservation of the Atlantic lobster and other species, I'm convinced that the federal government would gain in learning from Indigenous peoples, including the Mi'kmaq.
The recent response from the minister shows that a lot remains to be done and that the government response is not meeting yet the teachings of the Supreme Court. But I believe the Senate could assist in reconciliation. First, the Senate can play a public education role about treaty rights and the categories of fisheries. Commercial fisheries is not ancestral fishery or ritual fishery. Second, the Senate can play a role in depoliticizing the moderate livelihood fishery issue. We should, of course, take our leads from Senators Francis and Senator Christmas on other policy options for the Senate beyond this motion. However, I do think Senators' long tenure and policy lens are assets that could be helpful. In closing, Senators, I encourage you to adopt unanimously this motion in the spirit of the Peace and Friendship Treaties and of reconciliation. Thank you. Merci. Willaline.
Senator Wells.